नहीं तो अभी कोई है ही नहीं ना इसके लिए वहाँ पे। हाँ कैमरा ऐसा ना ये फुल है जो आप कैमरा ना बस ना इतने में आ रहा है सर ये देखो। हाँ तो अभी कोई बैठा नहीं उधर से बच्चे लोग आ जा रहे हैं तो अभी मैं ऐसे इतने पे करके छोड़ देता हूँ इतने पे इतने में सब आ रहा है इतने में तो आ रहा है ना सर। माइक लगा तो है माइक लगा है ना इसमें। हाँ हाँ तो क्या आवाज़ आ रही है जा रही है आपको आवाज़ मेरी। हाँ हेलो आवाज़ जा रही है क्या आपको? आई ना ठीक चलेगा चलेगा चलेगा। चल रहा है हमको देखेंगे कानून सब परेशान है भाई भाई हाँ यार यूट्यूब खोला अच्छा है पापा वाले अरे खोलो यार नहीं यूट्यूब खोला अरे यार पापा वाले को खोला पापा वाले लिंक शेयर कीजिए जाऊ तो मैं खोला अच्छा खाइए भेजिए पापा वाले भेज देते हैं अच्छा यही है अपने वाले he has to see in Puja as to how many packets and how many they are taking this. But they will come back to the item. You said it to me. You said it to me. I said it to her. Both said it. Both said it. Then he said it to me. So I can forward it to her. My recommendation to say this one. Either way, whatever. Not the way. I get so it's official. I don't get upset on all these things. You want to send it, or send it, send it. Whatever you want to send it, send it, you have to send it, receive it. So that it goes to her, that record remains. So she will be easier for her also to reply to you. I forward it to her, CC me, and tell her that please respond to her.
यथाशक्ति करे तो
लाइव चल रहा है, लाइव डाल दिया क्यों? नहीं लग रहा लड़की वाला
Good afternoon, everyone. I'm Dhanashri Datta, a senior member from CTRCR, and it is my privilege to welcome you all to the second National Corporate Client Counseling Competition 2026, organized by CTRCR. We serve as a platform to advance a dedicated scholarship dialogue and professional training in corporate and commercial laws. The National Corporate Client Counseling is one of our flagship initiatives, with this being our second edition, seeking to inculcate an essential lawyering skill, the ability to not just argue with the law, but to understand clients, mitigate risks, and deliver practical legal solutions. It is now my honor to introduce our esteemed panel of judges for the final rounds. We welcome Mr. Ashish Philip, Executive Partner from LPS with more than 10 years of experience, whose practice focuses on corporate and commercial advisory. He has a rich experience in advising various domestic and multinational companies in restructuring, M&A, tax, and corporate dispute resolution matters. We are privileged to have with us Mr. Rakesh Oja, a seasoned legal professional with over 40 years of experience as an advocate and an in-house counsel, specializing in contracts, corporate advisory, BFSI regulations, real estate laws, and risk mitigating strategies. We also welcome Mr. Harsh Munkar, Principal Associate from Charles Amarchand Mangalas and Co., who specializes in capital markets and advises investment banks and corporations on IPOs, rights issues, regulatory compliance, and market transactions. We also welcome Ms. Akira T.S., Associate Partner from KSK, with significant litigation and arbitration experience, representing clients across various judicial and arbitration forums. Her practice focuses on strategic dispute resolution, client-centric advisory, and emerging areas such as IP and cryptocurrency regulations. And finally, we welcome Ms. Silpi Parekh, who is partner in the insolvency and restructuring practice at Cyril Amarchand Mangalas, Mumbai, with over 9 years of experience advising banks, financial institutions, and stakeholders on debt restructuring and insolvency matters. We are deeply grateful to all the judges for honoring us with their presence here today. And with that, I congratulate the finalists for coming to the stage. I hope with great anticipation we hope for an engaging and insightful final round. Thank you so much, judges, for being here, and let us begin.
Good afternoon. I'm Akansha. We hope your commute to the office was comfortable. It was, the Bombay traffic. I know, right? Thank you for sparing the time and meeting with us today. As I already told you, I'm Akansha.
And I'm Aman.
We are senior associates and we're part of IBC team at Thakur Associates and Solicitors. Just to begin with, how would you like us to refer to you as?
My name is Neil Shah. Neil or Mr. Shah, anything works, whatever you guys are comfortable.
Oh, wonderful. So I have an experience of 10 years and my co-counsel has an experience of around 7 years in this area. So we can assure you that whatever advice we give you will be from the best of our capabilities. Before we begin, we would like to tell you that anything that we discuss in this session will be completely confidential and whatever you disclose to us will be protected by the attorney-client privilege and we will give you advice to the best of our capabilities again. Before we begin, we also would like to tell you that first we'll begin with asking you your side of the story and then we'll go on to discussing the legal issues together and then we can come up with the solutions that will be suitable as per your area.
So Neil will approach this session as a collaborative process and more so as a conversation because this is the first time that we're meeting. Furthermore, even though we have experience with relation to IBC, however, we can only help you if you paint the scenario well in front of us. I request you to be a little transparent and to tell me each and every fact that you know so that I can give you, both of us as a team can give you advice that will actually help your company and the position that you're in.
Thank you so much. All of your experience is incredibly reassuring. Do you guys want me to begin with my sentence?
Yes, please.
So, as I previously introduced myself, my name is Neil Shah. I'm an investment manager at AKS Asset Reconstruction Company. We are primarily a registered asset reconstruction company. And we specialize in, of course, taking in assets and further reconstructing them, going on with procedures, and so on, so on, so on. Of course, you're familiar with the gist of it. So, in 2023, we received a portfolio of distressed assets from the banks and so and so. And within this portfolio of distressed banks, we had one company, one real estate company called Vardhan Urban Developers Limited. And this is a real estate company that has offices and projects across NCR and Mumbai. And pursuant to this claim, we basically went ahead with the financial crediting procedure, and we had like a 320 crore claim on the company. This was of course secured through land parcels that were there in their ongoing projects, and any receivables on the same would also be a part of our security. Sadly, the company was facing a lot of financial strain. So on 10th of January, the corporate insolvency resolution process was initiated before the NCLT. And our company, AS, was made a member of the part of the committee of creditors. And herein, we subsequently had an 18% stake. We also had a resolution professional appointed for this and to facilitate the process of the same. Now, during when the process of the resolution process in itself started, of course, as an our course, the committee of creditors had several expression of interest release, and out of which the expression of interest of merit and reality fund was accepted after negotiations, and this was subsequently approved. And on the 3rd of January 2026, before the NCLT, the consideration and the application has been filed, and then it is subsequently pending. Now, I think the crux of the dispute and the reason why I am here in front of you as an investment manager lies such that I personally have some questions with regards to the resolution process in itself and the kind of allocation that has been made and the disadvantage that seems to be given to my company. Now, from what I understand, 40 to 45% of the admitted claims, these have been given to companies and creditors who have favored the resolution process. The expression of interest, the subsequent resolution plan that had come, Aegis had denied. We had not voted for the same. So it was passed with an 82% majority, and the 18% that did not, of course, support the plan was us. Now, the people who did, the financial creditors who did end up approving this, were again given a 40 to 45% claim of whatever they had, due. But when I look at the money that I'm receiving, I had 320 crores as my entire claim, and the valuation that I was given was somewhere around 80 to 85 crore, which you can imagine is 25%, 27%, somewhere across that line. So then we looked at what the valuation report is. What is it that they're sort of basing their claim on, right? And we get to know that there is this valuation report, and the valuation that they've done approximately is valuing us at 70 to 75 crores. However, when we look at a fair valuation that has been incurred upon, we see that our company at least deserves a claim of around 110 to 130 crores. So you can see there is a disparage here that I completely do not understand where it is happening. In fact, if I talk more about the report, the industry presently at the time of this process is going on, and the evaluation in itself, the investigation and all was conducted. The company and the market in itself, the real estate market, was going through a sort of a downturn. So I can imagine why the evaluations weren't so high. But now that the market has improved significantly, I fail to understand why that is not changed. I personally believe that should show a change within the revenue within the claims that has been given. That being said, I also suspect I also have questions with regards to the proceedings and the way they were conducted, and I do think some of it was suspicious guys. I'm very confused with regards to that. I personally do not think that it was completely fair. And this is perhaps the reason, and this is the reason, in fact, that I've approached Thakur and Associates, and I've come before you guys because I want to, sort of understand what to go ahead with, whether we should, let's say, engage with the stakeholders, whether we should object to whatever has been object to the resolution plan, whether we should look at alternative options. Coming into this session, my expectations, if I lay them down, they would simply be to understand the implications of the approved resolution. Secondly, what kind of options does Aegis have at this stage? And thirdly, the potential risks and benefits associated with any option and any course of action that we take. So that's primarily it.
So if I was to summarize what you just told us, the basic gist is that your claim was 320 crores. you weren't in favor of the resolution process,
Yes.
and the people who did vote in the favor of the resolution process
Yes.
got 40 to 45% of their admitted
Yes.
claims, right?
Yes.
There is another issue that you raised with regards to your company's valuation. You were valued at 75 crores, if I'm not wrong,
Yes.
and you want to be valued at 110.
That's what a fair assessment would look like.
Right, right.
Yeah.
And you also raised concerns with regard to the actual proceedings and whether the CIRP process in itself was valid enough,
Yes.
right?
Yes.
Is there any other?
I mean, just to,
area
I think my mom has to set up liquidation of the value, like, the value of the liquidation, not my company in itself, would be 75%.
Okay.
Yes, not the company, my company,
Right,
just
right.
the claim in itself, valuation of the claim.
Okay.
Do you mean to say the fair value?
No, either which ways, he said that the valuation of my company, I merely want to correct him, the valuation of the claim, not my company.
So, we get it. Firstly, we would like to begin with the three things that you said, that you want to understand the implications of the group resolution. You want to know if there are other alternatives that you have, and which either of the way would you want to go.
Yes.
So I would like to pose some questions to you
Of
to
course.
understand your factual scenario a little better, so that we can discuss the possible options you would have. So you said that there were some preferences given to certain creditors.
Yes.
So is this only your company's opinion, or even other creditors have had the same opinion? As you already told us that 84%, 82% people have already voted in favor of.
I mean, we were the only ones who weren't invited to the tea party because we were voted against.
Alright. Got it. Has the resolution professional initiated any action in this regard, or have you intimated them
I
regarding
mean,
this?
he has in fact approved, and he has told me that the requisite approvals has been processed in accordance with the applicable requirements. So he has really not said it. In fact, I do suspect that something. I believe that other parties, other creditors were much more forthcoming with the resolution profession. We were able to clarify any questions and whatsoever. Our experience has not been that forthcoming.
Yes. Understood. You stated the reason you feel there would be some misconduct or some red flag for that matter is because preferences were given to certain creditors like 40 to 45%. And
Yes.
you were saying something?
No, go on, please.
Yeah. They were given 40 to 45%, and while you were given 25 to 27% of the value you actually deserve.
Yes.
Right? Apart from this, do you see any other, do you have any other reason to believe that there could be a misconduct? Like, honestly, like you said that you are not invited to the tea party. So do you have any other reasons to
Of
believe?
Yes. So, I mean, subsequent to this validation and this whatever reports that have been given, I mean, I believe the procedure in general is that before the commission of creditors, you give us detailed valuations. However, we were only given a summary valuation report. So we were not given stuff like complete copies of the valuation report, detailed assignments, what assumptions were taken in this stage, what were the methodologies involved. We had no clarity with regards to the same, and only a summary report was presented to the commission of creditors. So that being said, then I personally, went and I independently went and I demanded that I be given complete valuation reports, right? But with regards to so that I get some clarity with regards to the procedure and itself that they followed, right? But then I was denied the same. And they said that they will only provide summary figures of the valuation. So that was one thing. Secondly, you can imagine how difficult it is to understand the entire valuation they've done has been based on those reports, and we have no access to those reports. So we cannot identify why we are getting a lesser share, why they are getting a higher share. In fact, as I previously pointed out, some of them also put more close to the resolution professionals, were more forthcoming about their assumptions, their doubts, their clarifications, and we did not have any similar engagement, and we only sort of relied on the summary information that was circulated to us. Go on, please.
Would you have any document proof of the same, your communication with the resolution professional and they denying the same, or you stating explicitly that the complete records were not presented in the meeting?
Any form of communication between
I believe I have requested when I gave in the request. I believe we have email communications with regarding the same. Right, but I mean that only. I mean the response was simply that we only provide summary reports as per procedure.
Just to clarify, what is your voting share in the
18%.
18%.
18%. I mean, it is also unclear that whether other people were given the clarifications that they asked for, or any additional clarification that we are not sure. But then I mean, you can obviously observe the kind of underhand things that might be going on.
Yes, understandable.
In fact, one more thing would be that the other financial creditors who've been given a higher amount, they also seem to have ongoing or prospective projects with the company.
Okay.
So perhaps that is, and we do not have any such engagement. So perhaps that could be something that is something that makes me believe that no one called me to the tea party.
Understandable. Your concerns are completely valid, Neil, and obviously on the basis of what you have just told us, we have a chain of email communication that you stated that you had conversation with the resolution professional where they denied you the
I mean, I personally did not overlook it, but I'm sure there must be some email communication because that is, I believe, the standard procedure. When I asked verbatim, face to face, that was the response that I had gotten. Let me look into that email communication first. I'll get you some more clarity on it, but whether in-house email.
Would you be able to provide us with the same if you find it?
Yes, of
I'll
course.
be able. So, did you try negotiating further your claim that you deserved? You were saying that fair value was different to what you were given, to what you were offered. Did you try negotiating more?
We have not as of yet protested. We have just, not, I mean, that I have come in a very, before any sort of protest has been made. This is what I want to understand. Should I object to this report? Or should I, look forward to engaging with other shareholders, other creditors? Should I file a complaint? This is what I've come to understand.
Yes, definitely. Neil, what I feel is that you should, from what you've told me, firstly, I asked you that whether see, this can be put on the table that you should firstly definitely talk to the other creditors, other main creditors that you are telling me have further future projects with the company. You should talk to them, and you should most definitely negotiate for the fair value share that you deserve.
Right.
Yes. And also one more thing, have you tried calculating the difference between the fair value and the liquidation value?
I mean, 110 to 130 crores is the fair value that we've been assessing,
Yes.
and what they're giving to us is 80 to 85 crores. So there's like a 40 crore gap in between the claims.
I'm asking about the liquidation value. If it has not been calculated, you can do it together. If the company goes for liquidation in future, what would you be getting if it gets rolled out?
I believe the company has gone in. I believe the values that I told previously are what would be applying the same. We are as if we are getting 80 to 85 crores as per whatever.
So Neil, from what I have just listened to, there are three wrongs that you are basically addressing, right? That there's this valuation wrong, right? With regards to the fair value and the value that you're getting. Then there is the thing of the projects, right? That other parties have projects with the RP, and that they did not provide any summary figures or the reports on the basis of which they have given a valuation to you.
I'm sorry.
Basically, they did not give the reports upon which they have valued your company, right?
Yes. Also, prospective commercial relationships with entities associated with the resolution applicant. I'm not sure if it is the RP in itself.
Okay, sure. So I know that you're here so that you can hear an answer. But what I want to know is, do you want to litigate?
What are tell me the benefits what are we looking at? I completely do not understand how long the process is going to be. What is the future looking like for us? Perhaps then I'll be able to, and what options do I have apart from litigation?
So, basically the timeline that goes on for around is 180 days plus an extension of 90 days. So, maximum will go on for around 330 days is what you have if you're asking for the timeline. Now, you asked for initially you said whether you should talk to the other creditors. So what would be my line of advice to you on the situation you're currently in? Firstly, you should definitely negotiate for more because that, uh, although the chances are of that is comparatively very less.
I believe the resolution plan is already in front of the NCLT, right?
Yes,
So
and it has already been approved.
Yes, so it's pending consideration by the NCLT.
Yes, by the COC.
Yes. So at this juncture, can we even begin with negotiations? Can I negotiate at this juncture?
Not with the resolution professional or in COC, but you can obviously do it out of the process if that is what you do.
Of course.
If that is feasible to you. Because you were here asking us if you should talk to the committee of creditors further and talk to them regarding this. So I am assuming from my end that you're not directly looking forward to the litigation. If you are, please let us know. I mean, what is your idea of this? Because this is currently not in your favor. The COC has approved the
Do you think litigation is a viable option in this circumstance? I want you to tell me what options do I have? One is, of course, talking to the creditors. The other is you suggesting is litigation. Anything further?
Honestly, talking to the creditors wouldn't help much because
Ha.
they already have
Yes,
what
yes,
they wanted in their
yes,
pockets.
yes.
So, and you, as per your knowledge right now, you're only one of the few creditors who are not happy with the
The
result.
only, perhaps.
Yes, the only, perhaps.
Yeah.
Yes. So, I think the only, and then there is misconduct.
Yes.
So, we can obviously challenge the process
Yes.
as it is, and the litigation would be the only, as per me, right now, feasible option because you're getting 80 crores
Yes,
right now
yes.
to what 110 crores you deserve.
Yes.
So, if, looking at the feasibility, obviously litigation is the more feasible option right now that we have. And we have a fair enough chance of getting that because we have the evidence of preferring the other creditors more when you when you deserve more fair value.
Right. So we have a fair shot at litigation is what you're telling me.
See, if you want to have a fair shot at litigation, the only thing that we need to do right now is, first of all, I need that communication from your legal team that you gave that the summary figures weren't given to you according to the report, right? So that's the first thing that we need to look at. The second thing is that we need to prove by an independent auditor your company's actual valuation of the claim. Right, so that you can show that there is a third person's perspective that your claim or the value that you are claiming is correct and the value that has been given by the via the CIRP process is wrong.
Right.
Thirdly, we need to show actually that the people who actually did get 40 to 45% of their admitted claims and that are way more than what you would get had projects involved and therefore they had an interest at play. So all these things could show misconduct. However, it would require a lot of proofreading documents and going through a lot of things to actually prove that something has happened with your company.
True. I think one more thing that I'd like to point out is that the settlement, I told you, right, 40 to 40%, 45% is what the other parties are getting. Now, this 40 to 45%, within this, 25% of this is being given to them as upfront cash, and the rest of them is being given in the form of other instruments of measurement, and that too, I think, in a very short period of time. Whereas the offer that we've been proposed is 20 to 25% that has been given to us, and that too in a triangulated way, spread out over 3 years, associated with milestones, project milestones, sales revenues. So the gain that we've been allotted also, that also is not as feasible as why are we not offered fair cash valuation? Why are we not being given any upfront cash? I think that is also one more thing that has been, bothering me about this. I mean, that we've been losing sleep because of this.
Considering all of this, also telling you one more thing why you'd be at a better place considering if we consider the litigation, because there's this waterfall mechanism at place as per which you're a secure creditor, right? Secure financial creditor. You have an upper hand where if we eventually go for the litigation, because as per the waterfall mechanism, you're just second at the place as per which the people to whom the money should go.
Right.
So you're in second in that priority list. If I were to explain it to you in a very simple way, just ignoring the legal jargon, that would be not relevant.
Point being that if the CIRP process would have failed, then you would have gotten money quicker. So this really shows that all of these things that you just told me, that there was this related party transactions and all these things, and these 3 to 4 things that you just mentioned, it shows that the COC wanted the resolution plan to be to go ahead with the resolution plan so that they would get a larger share and you would be just out of
Yeah, we are at jeopardy.
yeah.
And the first thing that you asked us amongst the 3 that you stated was understanding the implication of the approved resolution. If you go ahead with this approved resolution, you're obviously at a loss. And considering that you just told us that they're paying upfront cash to the other creditors, which is again unfavorable to you, I think the company is in a position where even after liquidation, which we're considering the liquidation, even if when the company goes for liquidation, they have to pay you, as I told you, that in the priority is to the second. So I definitely think we should go for the liquidation process rather than the CIRP process. If I were to explain the implication that you were trying to understand when you came to us first, when you're going for the CIRP process, first of all, there's this misconduct that has been happening.
Yes.
Second, you are getting less than the fair value. Liquidation value would be more than the fair value.
Yes.
Because as we have already calculated.
Yeah.
So definitely, as per us, the other alternatives, the second question that you asked for was the other alternatives. The other alternatives we have is the liquidation.
Right. So one option is either litigation, the other one is liquidation.
We will have to definitely challenge the CIRP because of the misconduct that has happened.
Right.
We have the proof of the same.
Right.
And once that we have proved that that has not happened as per the legal procedure that is established, and that once you stop that, obviously the company goes to liquidation.
Right.
And once that goes to liquidation, the waterfall mechanism comes into play, and you are second in that priority.
Right. Right. I think you have adequately addressed my concerns with regards to that particular question. Thank you.
Do you have any other questions?
Not as a such. I believe. So you were suggesting that should I challenge? Cannot challenge the resolution process at this juncture. That is out of the way. So I think we should go ahead with either litigation or liquidation, considering, and I'll send over the papers to you. So that's not going to be a challenge. And then perhaps in the next meeting we would really decide what we're looking for.
That is, apart from that, yes, I think we send up a follow-up mail concluding what we just discussed in the meeting today.
Right.
And in that, reverting to the same, you could send us the chain of those emails if you could, please.
Right.
And other thing, yes, also we would like the calculation that you came up with, which calculated 110 crores.
Yes, the fair valuation.
Yes.
Yeah.
Could you please send us?
Yes, I'll send you the fair value assessment.
I think, yes, we can discuss further in the next session that we're going to have. And today's session was free of cost, as we already discussed. For the rest, you can contact our finance team. They'll send you the fee structure of the same.
Right, that's wonderful. Thank you.
Thank you. We will see you next week.
Of course.
What do you want to discuss?
So, what do you think? What position is she?
I think she should go towards litigation because it's very clear that her company has been cornered, and just because she was cornered, she couldn't get the share of her pie. And I think litigation is the basic agenda in my mind. If you want to suggest something else, I think I'm all ears.
I couldn't understand the point that the reason only her company was cornered in this, and all other creditors wouldn't have had their future plans with the company, right? That doesn't sit well. But anyway, even I think if there is misconduct involved, and if she's not getting the share that she deserves, it's not even fair value. I think the only option that we're left with is somehow making the company go to liquidation so she can get her share of the value.
See, I think there are four things that will work out in our favor in proving misconduct. The first thing is that the pyramid scheme she told about as to how she would get repaid in comparison to the other creditors. Secondly, how they were involved in projects that are of interest. Thirdly, with regards to the valuation that was given to her claim, which was I think around 80 crores short, and the summary figures which was based upon the report, and the report wasn't really made public even though she asked for it explicitly. So I think these 4 to 5 factors will work in our favor while proving misconduct. Again, I think she was just cornered and she couldn't really.
That is the point. Apart from that, I think the chain of mails will be able to tell us even better as to what the resolution professional was actually dealing with when she asked for the same. Because she said he also went ahead with plan and approved that, and now it is in front of the NCLT. And also, yes, we can also await the NCLT order. If there is, we can
Yeah.
challenge it in front of the NCLT too. If
If it isn't.
if yes, we definitely can challenge it, stating that the established procedure was not followed. We have chain of proofs where the resolution professional has explicitly denied giving the reports to our client. So I think they would obviously do their own share of scrutiny. The NCLT would do their share of scrutiny before approving the plan. But if that goes ahead, you can obviously challenge that any day. And that is what we suggested her as well, that we should obviously go ahead with that. And then, as we told her that liquidation will give her share of the value.
Do you want to add anything else?
I think we're good with this thing.
So I've come back to you as my client, as the same client. Will you hear me?
Yes.
Give me what would you advise in step-wise? Or what do you understood on the problem? Step-wise, okay, these are the 3 solutions, A, B, C.
Is that now that the resolution, am I audible? Now that the resolution profession has already, approved the plan, and COC has approved that, we do not have many options left apart from, well, we are trying as well as you have made it corner. So I think the only thing we would have left is challenging the misconduct. That the group also will have to say.
When you are talking to the client, you kept on saying the word litigation. What litigation did you have in mind? The fault, and why you thereafter stated you went into liquidation? The answers for questions for both of you, not any individual.
I personally thought there was not a lot of other options left, but the
So, question is, what do you mean by litigation? Also, litigation, what are you thinking of?
outside challenging the
As what, under what? Specify.
before NCLT.
Specific.
As what?
As what? Under what?
So-
Section.
Some litigation you said, right? What did you have in your mind?
Yes, it will be challenged. You will challenge that as misconduct before the NCLT.
What about papers? Why don't you ask? What paper did you ask? Why were you going here and there? What exactly do you want from the client to be able to assess, analyze this?
That you will ask me for the proof of
You already said, kept on using the word we have proof, we have proof. Where's the proof? Then how do you know is the chain of case? She said she did not know. She kept on saying one thing, there must have been. She never said I know that they will. Did she say that? She kept on saying that there must be. And you kept on using the word proof. As a lawyer, what exactly do you want? Don't you want to see the papers first before even advising something? So now forget all that. What do you want from them in terms of documents? Relax slowly, don't worry. There's nothing else. What would you ask? Common sense. What would you want?
Sir, the actual value of the claim, and I suggested the same because with regard to a third party auditor, if the auditor could have showed that the claim that she is claiming is actually worth way more than what she's getting, then it would work out in her favor. And with regards to the documents, I think the first thing that she said was that she wasn't provided a report when she asked for the same. So,
First thing should be when is the recognition making a report? If you ask for somebody's misconduct, usually first proof you want is that I want a report. This is natural justice, right? You ask for something you do not want. So first thing you want is whether you ask for it appropriately. So that begins if you're going to go to misconduct. Anyway, carry on. Then
and then, sir, another thing that she mentioned was how she was getting repaid in comparison to the other creditors. I think that will also work out in our favor when it comes to litigation.
where did you get that from?
So she mentioned,
You are advising her. She can mention anything. I am the client. I want to move.
sir,
You are supposed to tell me that to come down on the earth.
other creditors are being repaid way more and that too in a better
How do you know?
She mentioned that they were 20%, they were getting 20% upfront cash.
So you accept her word.
So if the
So they
client
ask for the documents that the meeting, the CO,
First thing you
complaint
tell her,
letters
first you tell
needed.
her, get me all this, then only I will be able to advise you. Unless she gives you, she's a, she, what about contract with other companies? How do you know she also does not know, she's also conjecturing. How will you show that? You are talking somebody's misconduct. Because you're going to a misconduct of a litigation, of the RP or whatever. Then how would you navigate towards that? What would you need to navigate? You should now, uh, you should now discuss it. What exactly do you need if tomorrow she comes back and says, okay, let's do litigation. How would you prepare?
There are two parts to your advice. The first part is your entitlement, and the second part is misconduct that we're talking about, right? I want to understand from you on the entitlement. Keep in mind that they voted against the resolution plan. As a dissenting candidate, that's not the most important one. But in the resolution process, as a dissenting financial creditor, what is their entitlement? Like, what did you think of those rules?
her company actually has a secured financial creditor. So as
That's fine. Let's leave aside the security. We'll come to that in the next part. The first part is as a dissenting financial creditor in the resolution process, what is their entitlement? Do you want, like, as a client, I want to know what do you think is my entitlement at this time? Forget about it.
And just see the would get what they initially offered to do.
The position of law, I don't know where it comes from. They would be something that's fine. So position of law is the dissenting financial creditor. You are entitled to dissent at least the value that you are receiving in case of liquidation. You are emphasizing on as an advisor, if you're thinking more and then you need to touch upon, you need to understand what the entitlement is as a dissenting creditor. Then you can advise them. Look at the statute book. If that's the entitlement, the fair value criteria is it relevant? Is it medical? Because you did ask that question. It was right. You asked that there's a liquidation value concept. Do you think it's really crucial for them to take a decision? Then I have one more question. I think you mentioned one more. We will not discuss on the other
You also remember the liquidation of the company. We are more interested in the liquidation that we claim. 70 versus 80, 85 versus 110, 150. And versus fair value versus what is the real estate. All this would either she was not clear or you didn't ask. So you have to now decide whether what was the gap.
As part of the process, when you ask for misconduct, what if you're saying she's been cornered, etc., that doesn't matter. In insolvency, that is irrelevant. But if you're talking that there is a compromise with the process, what is the kind of relief that you are asking? What do you have in mind? You approach the NCL. What do you want the writing for? When you approach the NCL, what do you think you have in mind? What is the kind of relief that you want to get or what is it? That's fine. I agree. Assume that the process is compromised. What kind of relief are you asking from the NCL?
So share the plan.
You already have the plan. Shelf the process, cancel the process, and then you move on. Then the company, what is the consequence? You want the company to go into liquidation?
Through this process, she was not getting what she actually wanted. That is what the factor is I could
You're still getting 80-85 crores. It's a matter of, so that ties into the previous thing. She is getting 90. Therefore, is it even worth it? Because she will earn 80-85 crores. Is that even realistic to go for liquidation for the loss of 10
And she said her entitlement was around 110.
That's fair value. Fair value is different from liquidation.
Fair value she said was 85 crores. Liquidation value she said was 110.
And
And you're getting confused. I don't think the liquidation value. Liquidation value, her claim is 110. How is it complete?
you also suggested one course of action. Speak to other guys. How does it like you think that is going to help?
She answered the same question that could just paying for what is not. What's that going to
Look up any three of you stick to good side of stories that you want to see your strategy. Also good strategy. I'm completely like I understand that your brief was just a very tiny 5 sentence paragraph. And it did highlight the fact that we're trying to become a community that has writers who can take an IBC. So just keep brass tacks. I understand sort of there was massive information asymmetry. I think we'll take a minute. I know I could have done a little bit of a better job in terms of acquisition for data sets like this. Can you just like quickly, and I know he alluded to it from the start, just give me like a 10-20 second summation. What are the steps? The second the COC, the committee of creditors, have in fact approved the resolution process, which is now going to be going to the state. Because you kept hitting up on litigation. Oh, it's admitted to the NCLT. Second, okay, I mean, it's admitted, right? Litigation करना है. What are the from what you've read up on IBC provisions, chapter section 51, like what is happening? What do you think is going to happen to a dissenting guy who's just dissenting? Like, what's the strategy when we go? Is it dissent?
It's your advantage. You already said your advantage.
And then comes a law position. You would have studied a little bit, right? Because this isn't just a sample negotiation competition. And I know you asked them to negotiate with the other participants within the COC bracket. In terms of brokerage law, very basics, is it possible for the dissenting guy to opt for liquidation, or do you feel like in front of the NCLT, you had to challenge that entire process, the entire resolution process, before you could even have an opportunity to move for liquidation? Did you read up on this? Do you understand what that is?
And a very simple question. How do you think liquidation happens? Exactly. So see that triggers liquidation, right? So how can you give two options, either litigation or liquidation? Doesn't matter. And when you're talking about liquidation, be very specific. Or when you're talking about litigation, be very specific. How can the client go before the incident? How can he approach the incident? Do what? They file an objection, correct? They raise what is the misconduct that's made. They raise things that are probably alleged with respect to the claim itself or the scheme itself.
And just only from a student perspective, and we have missed this out while we were having the discussion. Did you at all touch base on the differential treatment linked to the security value which she was trying to enforce? Any parivasu treatment of the security that she had vis-a-vis the other 78% of the people?
Yes, sir, I did touch upon this.
You did? What was the
Actually, she was the one who initiated it because she said that the way that other creditors were being liquidated in comparison to
the parivasu actual security value? What is the security value? Like, basically, is there do all five of the creditors have security of the same parcel of land? This is a large developer company, right? So I just want to understand, was that part of your strategy to understand when she started with the narration to see priority in terms of not your Companies Act repayment or in terms of liquidation, priority of security and enforcement that all the creditors have already undertaken, or any of the securities? Was that part of the strategy?
You highlighted some options. What are the risks that you want to highlight your client? Because it can't be like, everything is great, you will get to what you want. So if you highlighted them the good things, what are the risks that you want to talk about?
Last question. General question. What do you think? Like, plan is approved by COC. What powers NCLT has?
Plan is supposed to be
COC.
the plan also is scrutinize the thing they as a power to scrutinize new procedures followed or not. But they cannot go into the intricacies of whether the COCs took the decision correctly or not. Because that is more of business perspective they consider. So CFT cannot impose in that, but they just see the things procedures followed or not. Legally.
Yeah, that's okay.
Even the second question you mentioned.
No, don't share. Next week. As of that. Yeah.
Just relevant to what the next meeting. Let's close it. We'll part from the publication. Good here. But I absolutely horror. Strong, yes. Yes. Before camps and office, I started AMSS. That's called AM. What do AMSS? AMHS. Social Nutrition. Like, which are another show. I started off with taking off slides. Then, just according to computer. I started choice. Yeah. Just I have now transitioned to this senior level. Old school lawyers. But they do plan that. If we need this course, so that, yeah, at the bottom, show you.
Good evening, Mr. Welcome to Thakur Advocates and Solicitors. I hope you did not encounter any trouble while finding our office today.
Just the heat and traffic in Bombay. Apart from that, no problem. Thank you.
Alright. So I am Ved Gupta. I am the partner heading our insolvency and bankruptcy division at the firm. While today with me is my senior associate, Ruchir Khurana, who is also involved in the insolvency and bankruptcy team at our firm. That being said, would you like us to call you Miss Shah, or would you be amenable to something less formal?
Mr. Neil or Mr. Shah would be fine. Thank you.
Alright, Shah.
Hello, Mr. Shah. Good afternoon. I think this might be one of the first formal legal consultations of this nature for you.
Yes.
So let me set the stage up for you. Some foundational points before we go into the deep discussions related to the problem that you have. First and most important, that the entire session today is covered by confidentiality. We would be taking notes, but that would be strictly for our internal purposes, and no third party will have access to it. We have also executed non-disclosure agreements, which already bears the signs, and we'll share it with you after the meeting. Secondly, today's session is expected to last approximately 30 minutes. We'll first hear your account and then ask you a few clarificatory questions so as to better understand what your particular dispute is. After that, we'll offer and try to navigate the legal nuances and also see what we can advise you in terms of what is the course of action you can take moving forward. Thirdly, on fees, today's session is complimentary. You will not be charged for this. If going forward you want to continue with our firm, we share our retainer agreements with you. And lastly, as a matter of conflict of interest, if at any point we get to know that any firm involved in this transaction is a pre-existing client, we would be extremely transparent with you, and we would be more than willing to guide you to an equally capable counsel. If you have no further questions, please let us know what you receive here today.
Thank you so much for that assurance. It is really incredible, and I am researched by your great experience within the field itself. So, as I previously said, my name is Mr. Neil Shah. I'm the investment manager at AGS Asset Reconstruction Company. We're basically an asset reconstruction company, and the dispute at hand for which I've come to you is essentially back in 2023, we had received a portfolio of investments of distressed assets from banks and so on and so forth. And one of those was this company called Vardhan Urban Developers Limited. Now, as the name says, these guys are a real estate company, and they have projects all across Bombay and the NCR in itself. And of course, pursuant to this assignment, we became their creditors, and we, I think, have a total. And we had a claim of around 320 crores at that point of time, and this claim was of course secured through land assets, through land parcels that would be formed, that were part of their future ongoing projects, and I mean the associated receivables also would also subsequently come to us. Now, sadly, the company was going through a lot of financial strain, and hence on 10th of January, an application before the NCLAT was filed, NCLT was filed for the beginning of the corporate insolvency proceedings. And subsequently, a committee of creditors were formed, and a resolution professional was also appointed for the same. Now, within this committee of creditors, my company, which is AAS, we had an 18% stake. As the procedure, goes, a lot of EOIs were circulated with regards to the resolution plan. And finally, this company called Meridian Reality, their EOI was sort of finalized. And this is the one that the resolution plan finally went ahead with. This resolution plan had everyone's vote in it and was passed through a majority of 82%. But as you can imagine, except from us, we sort of refrained from voting on to this resolution plan. And on the 3rd of January, the resolution plan, an application for the approval of the resolution plan was filed before the NCLT, 3rd of January 2026. Now, the concern by which that I've primarily come to you is that I'm unsure as to the procedure that they followed and as to what the valuations that have been given. There seems to be significant discrepancies between what my company has gotten and what other financial creditors have gotten. So, for example, other companies who acceded to the so-called resolution plan, they are getting 40 to 45% return on their claim, right? And whereas when I look at my own company, we did not agree to this resolution plan, and I believe we are being punished for it because we are getting 20 to 25% to 27% rate, which sums up to what? 80 crore rupees out of 320. So you can imagine the discrepancy that is there, which I personally cannot find any reason to. And even if you look at the way the payment is done, there also are significant difficulties in those also. That being said, I believe I believe there's been a dispute. I mean, I believe the valuation that they're giving us also, that they're relying upon, also the reports that they're relying also are not completely accurate. And I also do think that there are certain under the hand things, there is a certain bias within the procedure in itself, which I would like to sort of, hear your inputs on, because I do think some things that have been dealt with here are not completely transparent. And I mean, what matters the most in such a procedure is, of course, transparency, no conflict of interest, all of those things, right? So I personally feel like my company has been, the functioning has been prejudiced towards my company simply because we did not go with this so-and-so resolution plan. So now I've come to you and I want to understand a couple of things. I want to understand what should I do, whether I should raise objections against the resolution plan, whether I should engage with other stakeholders, or what alternative courses of actions do I have. To put it very clearly what my expectations are from this session, I would like to seek advice on the implications of the approved resolution plan, the options available to AAS at this stage, and thirdly, the potential risks and benefits associated with any or each course of action that we take in this matter. And I would, of course, make sure, we're business professionals, so we would want that, whatever procedure that we undertake should be efficient and effective for our company. And this is why I've approached Thakur and Associates for their, experience in this.
I understand your concern, Ms. Shah. However, we must understand that Thakur Associates is a firm which has built its name in the insolvency and dispute resolution practice. So rest assured, I understand it can be overwhelming to navigate this complex dispute, but our sole objective today is to ensure that you work out better informed through this entire process. However, that being said, we just have a few clarificatory questions that will help us understand better your position and your case to this effect. So, starting first, you said that you refrained from voting to the resolution plan. What do you mean by you refrained from voting to the resolution plan? Is it that you abstained from voting or did you vote in the negative?
We voted in the negative. It was passed by a majority of 82%. So we did not vote for it.
Alright, so you voted for it in the negative, that is at this.
Yes.
Also, can you please tell us more about what do you mean by under the hand, non-transparent actions or transactions to that effect? Do you have any minutes of the meeting records or anything else material on record to suggest that these are not mere allegations? I mean, I attribute full good faith to you, but you must demonstrate via documents full additional proof to the court to make up a case for it.
So I'll tell you what has happened in this circumstance. Now, you must understand that anywhere where an allegation is being raised, the reports are what is at the crux of it. You know, whatever they valued us. So generally, from what I've been, I mean, in all the procedures that I've been involved, we generally get the valuation reports. We get, you know, the assumptions that they've taken in, the biases that could be affected, the complete copies, the registered values, all those details are generally provided. But in this situation, within the committee of directors, only the summary reports were given to us. So we could not completely, I mean, personally, I could not completely understand why my company has been disfavored in such a circumstance because I don't understand what has gone on, and then I don't understand the numbers because I've not been given any numbers. So in such a circumstance, I requested access to these reports. And still, I was not provided with these reports, and it was said that only the summary figures would be made available. So, this is one of the things. Now, that I mean, in itself has significantly confused me because generally, when these reports are the main foundational document that are being relied upon, I don't understand why I have not been provided with the same. Secondly, I would like to point out that some creditors within this committee, within the committee of creditors, were more closely associated with the officer. And I mean, they asked during the valuation process also, they had engaged more closely and they had asked questions. And I mean, they had that sort of clarity about those assumptions. Now, I don't know if they were given any such sort of clarity, but it did seem to me that, we did not have any such engagement with the profession at that time. Again, of course, one more thing that I personally think just raises questions upon the procedure in itself is that all these companies, these other companies, those who have been preferred, they seem to have ongoing or prospective engagements with the prospective commercial engagements with the entities associated with the resolution applicant. So I personally think that puts me in a prejudiced position, and I personally think that I mean, of course, that validly raises, there's a lot of gray, there's like murky water here, so I don't understand how that also seemed to have occurred. And surprisingly, the RP has given all the requisite approvals. When I spoke to him, he has said to me that all the processes have been done, all the requisite approvals have been done. So I don't understand. You can understand my hesitancy in this matter. This is perhaps the thing that this is perhaps a quantum of what I think has gone out. I mean, I can only tell you what I saw and what has happened in front of me, but I'm not sure. We can only imagine what has happened. And we know what happened at this morning. We were not in the guest list for sure.
Mr. Shah, that's a very important insight that you have given to us. And I want to reassure you today that as a secured creditor, you had the right to be on the COC as you were, and you also had the right to access these documents. We'll get into the legal nuances further, but another question I wanted to ask you was that on this valuation, do you know if the RP conducted any independent valuation, or how was that valuation actually leaked, or did you not even have access?
That's correct. I have no idea how the valuation reports, which have been based, which are the basis of the entire findings of the RP and the subsequent procedure, I have no idea. I've only been given summary versions of them. This is perhaps a concern I was attempting to raise, right? Give me what has happened, what is the methodology used, but then I have no clarity on this.
Correct. I do understand that. See, when you're given a summary report, you don't know what the summary
Exactly.
report is based on. So even if the report is adopted, you don't know the methodology to which the report was pursued to that effect. So we'll take this up further, but moving on with our questions, do you have anything material on record to suggest that the resolution professional was incompetent in the first place, to act for the resolution plan?
I-
Like, do you have any information with respect to his companies, or whether he's a guarantee to any company which is defaulting, or whether he has been personally involved in some debts or otherwise?
I personally do not have enough information to allege him of something. We do, in fact, if I talk about any communications or documents, I do have it on email. That I asked him for the summary report findings and he denied it for me. But that is perhaps the only documentation I have of this entire. I would not comment on his qualifications.
On valuations again. So for your own assessment, that it is only being paid to you for 25 to 27%, which roughly would be around 80 crores if I am not wrong.
80 to 85.
80 to 85 crores, that would be. As against the 40 to 45% that is being given to other people who voted in favor of the resolution
Yes.
plan. I wanted to ask, what do you think is the particular relation between the resolution professional and these people? I know you told us today that there are maybe these people have had continuous engagements in their other resolutions with this RP, but can you expand a bit on that?
I mean, I do not completely have the, I cannot completely accuse the resolution professional of, let's say, being unprofessional or unworthy. But I mean, we've just observed from as per our observations that these financial creditors who supported the resolution plan did seem to have existing or prospective commercial relations with the entities associated with the resolution applicant. So I mean, I do not accuse anyone out of my way, but you see, it's a lot of murky water. Sometimes what I felt, there's no clarity. That they refuse to give any clarity. It's like a black curtain has fallen over to this process.
We completely understand the frustration at hand, and it's a difficult position to navigate, honestly. But Ms. Shah, I just like to clarify one thing. Has the resolution plan been passed by NCLT, or is it pending
It's
judicial
pending.
approval?
It's pending.
It's pending
Yes,
judicial
the
approval.
application is pending. Again, when I talk about the valuation in itself, one more thing that I recall just now is now the 40 to 45% that they've been given, right? They've been given this 25% upfront cash, and the rest of this they've given them via instruments, right? That will be given out. The payment of this would be, would be sorted out shortly. Whereas when I look at my company and what we are being paid, we are again being given 80 to 85 crores, which is again a redacted amount in the first place. But apart from that, these payments, none of them are upfront cash, and all of them are incentive project milestone basis. So if we hit X and X sales target, or if we hit X and X project completion, only then in a staggered manner is my company getting any sort of payment, and that too over the tenure of 3 years.
Okay, so if I understand this correctly, Mr. Shah, you have not received any payment for the in-persons of the resolution plan yet?
Not as of yet. Not as of yet. But the mechanisms of payment within the resolution plan, again, sound a little shady to me.
Correct. I understand. Ruchir, if you like to elaborate more on the liquidation or the valuation aspect of it.
On the valuation aspect, I think to give you a preliminary idea, while not getting into too much legal jargon, there's a requirement that in any liquidation plan, there should at least be a minimum floor for what would have been an independent valuation. So that's why I was trying to ask earlier also, and I want to ask again. Do you think that there has been any independent valuation conducted by, say, Aegis itself or any other?
We did conduct a fair valuation assessment. And as for that, so two things that happened here. If you look at the liquidation value that they are attributing to us, that is around 75 crores of whatever had happened, right? And when we conducted a fair evaluation and assessment on our end, we could see that the number that we are getting is around 110 to 130 crores. And I mean, another thing that probably plays into this is, of course, that at the time that the earlier evaluations were made, the real estate market was in the downturn. Right, the war and the economy, all of that factors were obviously affecting the market in itself. But now the market has improved. So I fail to see any reason why perhaps the present valuation or a fair valuation is not taken into consideration.
Mr. Shah, what would you say would have been the change, or if you could quantify it from the valuation back then, which was I think 100 to 110 to 130 crores, to now when the market has gotten much better.
110 and 130 crores is the valuation that the market is doing fair.
Okay.
This is the fair valuation that we think should perhaps hold in the very least. What they are giving us is around 75, what the liquidation minimum is around 75 crores. And what we are getting as of yet is somewhere around 80 to 85 crores. But you still see there is a tranche of around 30 to 40 crores here that is not met.
Just a small follow-up. So the independent report that was conducted by Aegis, can you tell at what point was it conducted? Like, was it conducted when the plan was still before it was passed, or at what exact stage was it covered? Because the 100 to 110 or 130 crores valuation is what the fair valuation is as of today. Was there any report conducted earlier also?
So we conducted a report, a fair evaluation report after the initial liquidation reports were made in. At that juncture, of course, the market was not doing well. Now it was. That is when we conducted our own liquidation report, and we did take in more optimistic assumptions of the market and of the current financial situation in the country.
I think they would have a few more things to contribute.
Of course, please shoot your questions.
Correct. So just a few questions before we actually jump into giving you some preliminary advice. Mr. Shah, could you just tell us more about the voting procedure and the how did the voting conclude? So were there specific coalitions, or were you a part of specific coalitions, or were there some lobbying that will be recorded in the minutes of the meeting or otherwise? And what does your board of approval, or what does your board say with respect to it?
I would not comment on any lobbying done in the MOMs. I'm not sure if it's on word per se. But certainly we were not part of any such lobby or any such associations within the financial creditor, within the Commission of Creditors. We usually take a very transparent approach, and that is what we have taken in. And if I talk about the voting shares, and previously also said, it was around 82% that from which it had been passed. We were the only ones who had sort of negated the voting.
Just to summarize, because there has been a lot of information exchange,
Of course.
so that we can finally move on to the legal assessment. Aegis had an 18% share and 18% voting rights in the COC. A resolution plan was proposed and it was passed, but there is a high chance that the valuation reports which were provided were not independently verified, and Aegis doesn't have the access to the actual reports. It has barely summaries.
Yes.
Further, there are chances of more closer association of the RP with the other parties which have favored it and have gotten a more favorable valuation, which goes to the extent of 40 to 45%, as against the 25 to 27% of ours. Further, an independent survey has also been conducted by Aegis, and it is also important to note that the reports have to be in a way more transparent, is what our request has been.
Yes, of course. I mean, transparency is crucial in the procedure that I personally have not seen through this one.
I think now they can proceed with the legal analysis and the preliminary advice that we would like to give.
Yes, of course.
So, Mr. Shah, now that we have a holistic understanding of the problem at hand, so first, we believe that we may be able to argue before NCLT that this is a case that might be initiated by, say, fraud or unfair trade practices for that effect. And I'll be honest with you, the standard of proof for alleging fraud or proving fraud is extremely high. So we need supporting documents from you that actually corroborate whatever we allege with the material reality on ground. I'll be sharing a list of documents that I necessarily need for you, and then follow up on certain more.
But is litigation the only option I have in such a circumstance? What are the options I have?
You can either proceed with the for example, if the resolution plan is passed, the other creditors are going on. Well, you told me that they've already received upfront cash, and your benefits
they will be receiving upfront cash. I just showed you what the plan is.
Correct.
I'm not sure if the conclusion of it, the cash payments have been transacted as yet. This is the resolution plan. Within the resolution plan, they would receive cash payments, and I don't know.
Correct, and your prospects are tied to future projects.
Yes, yes.
So either we can go for, say, we can pitch for liquidation to the effect and realize our 75 to 80 crores. Because see, you asked us, I mean, you told us that according to evaluation carried out, you was 110 to 150 crores.
Yes.
But then we must also understand that tomorrow, if I go to some adjudicating authority and tell them that I carried out a fair and independent valuation, they're not going to take my word for it. I need to have an independent accounting expert, be it say a big four firm or otherwise, that must corroborate that and pitch it to that effect. However, that being said, if you are a dissenting secured creditor to an extent, you have certain rights, which include that you will necessarily receive whatever the minimum liquidation floor value of the real estate project was, irrespective of what the case turns out to be with the COC. And
The money I received through this liquidation, it will be like upfront cash payment that will be given to me after the process is done? Or is it going to be spread out? I mean, what is the timeline that we're looking at if we look at liquidation? And I only get 75 crore as a minimum threshold.
Mr. Shah, I want to offer a few clarifications so that we can even navigate this legal terrain to a more simpler procedure. The first one being that there is a requirement that if there was an independent survey conducted, which was a requirement by the RP, and if it was, say, wrong in the terms of other valuations, like you said, could have been 110 crore also, then that would itself be negative.
Right.
The reason that this is important at this stage, and why your question about why other options are not, we are not suggesting other options. It is important to know that the resolution plan has been passed and it has been presented in front of NCLT. Now, our first immediate concern here is to ensure that the plan at NCLT is strong.
Of course.
That we can do through a statutory mean, which, just to put it simply, is to, if we have a floor which is gauged by this independent test, if it is below the price, then the plan itself would not be allowed. In that way, the 75 crores would not be allowed go. The plan would not succeed. Thus, they would not be able to go on with the current plan, which would mean, as against your question, whether the 75 to 80 crores would be in front of cash or it would it be in front of tranches, that would not be the case because a new resolution plan would be needed.
So, in the resolution plan that has been proposed, 80 to 85 crores is what I'm getting. The minimum liquidation that I assume that should be allotted to me is 75 crores. And what I think is a fair assessment is around 110 to 120 crores. So, in such a case, also will the resolution plan fail in front of the NCLT?
The 75 crores you were referring to, I am the 75 crores is not the independent RP report, right?
The independent report that we have conducted gives us 110 to 120 crores. The money that we are getting as per the resolution plan is 80 to 85 crores, and I think the bare bone liquidation from the valuation report is 75 crores.
Alright, so I think that clears the air for us around the numbers. So
Yes.
see, if see the resolution plan is over the limit of what your minimum liquidation floor value is. So we cannot really challenge the
Yes, that's
resolution plan on that particular merit. However, that being said, to realize, so I understand you are an asset restructuring company, and I understand the risks associated with this, that you need to purchase a non-performing asset in the first place and then champion it for it to perform better. So to that end, I think we must pursue this fraud argument before
Yes.
the court, that okay, we are alleging fraud, but that allegation is not through some fictional means, and we're corroborating it through legal documents, and then we can place everything on record to say whatever you suggested to us, that the outcome of the prospective plans of the applicant were tied to whoever was getting more share in the plan. Additionally, the patent illegality with the process, that the discrepancies valuation that they got 40 to 45% in return, whereas you received only 25 to 27% in return. Additionally, what has been proposed by the resolution professional in that matter, that your benefits or your prospects are only tied to the future, which we do not know whether they'll be able to realize it or not. So I think those are the merits that we should challenge this resolution plan on, and I think Ruchir has more to add on this.
Also, because an important part of our discussion today and of your concern has been the conduct of the RP. I want to underscore a very, very important fact, which is that RP is a fiduciary, acts as a fiduciary character. It is not there to favor any creditor over others. So, conflict of interest is a very important thing which an RP has to avoid. So, if there has been any possibility, which I think it is very we agree with you and your tone where we don't want to allege anything out front, and we also like to follow up with the minutes as Ved was pointing to. But if there was any of such a miscarriage of such a character, you will rest assured have a good case, and the resolution person would have to account for it or be penalized for it. The second point which I want to emphasize is the fact that the RP, the valuation it gives is an independent assessment tied to a report. So the fact that they only gave you summaries is also a breach of your
Right.
So the fact is that as a member of the COC and also as a secured creditor, you had the rights to get access to the meetings. You had the right to get access to the documents which were relied upon. So you have a strong case when it comes to the RP in that sense. I think today's it would be better if way could provide you a more comprehensive suggestion as to the approach we are suggesting, so that you could also clarify with respect to the remedies and challenges that you were concerned about.
Correct. So, Mr. Shah, you raised three important agendas recently. First was the implications of the resolution plan, which we've addressed, that we are challenging this in the court on grounds of fraud. Second was what are the necessary consequences thereof. And third, you wanted to understand what are the risks and benefits associated, and you wanted to have an efficient and fast track and speedy resolution. See, Mr. Shah, I'll be completely honest with you. Since this is before NCLT and we are employing a judicial perspective to it, it might get a little delayed considering there'll be appeals to it, there'll be adjournments, and I mean, the entire process may be prolonged for that matter. However, that being said, since the resolution plan has been passed, the very first thing that we need to do in any case is to get it struck down. We need to get the resolution plan scrapped in any case. So, towards a short-term basis, first we'll be arguing for the NCLT for the resolution plan to get scrapped down. And on a long-term basis, see, I understand you want to realize your additional rights that have been accrued up to the rising rates of real estate. What we can potentially do then is, once the resolution plan has been over, then we can proceed under SARFACI or any other competent act to, have a fair valuation and conduct prices again.
That sounds incredible to me. Thank you so much. You have greatly assuaged my fears of what is happening here. I lost a lot of sleep before this, so I'll just go and tuck myself into that. Thank you so much. This is always incredibly assuring.
No worries, Mr. Shah. I understand this can be completely overwhelming, and we're here to assist you in the best possible manner.
Thank you so much.
Hello, Karthik. So, how did you feel the session went by? I mean, if you ask about me, I felt Mr. Shah was very candid, very open about what the concerns were, and I think she was well informed about her business as well. So she laid down everything in detail, but I believe whatever assessment that we've given her today is necessarily preliminary, subject to whatever documents we get, whatever minutes of the meeting, whatever actual corroboration that we actually make to court. Until we get them, all advice that we've offered to them is necessary preliminary. But then otherwise, how do you feel this session went, and how do you see this going forward?
I think the most important thing which I like about this session particularly was that Mr. Shah was very forthcoming and very good with his numbers. He was very transparent with us, and he was also very aware of his business. That shows both the possibility of a more conducive procedure in the sense that we can get documents and have a more faster approach and more efficient approach. And also, legally speaking, there was a very important thing which I understood from Mr. Shah's approach is that there has been a lot of miscarriage and misinformation which has been bothering him. So I think as legal counsel, it is very important for us to repose trust in the client that there has been some rights which you have personally, like you had the right to get access to these documents through transparency, and also that we would have further rights if we are able to understand properly and assess after we get the documents what are the possible remedies going forward and why are we choosing a particular outcome over another or suggesting a particular remedy over another.
Correct. I completely understand. I was facing this dilemma when I was proposing this NCLT adjudication challenge of resolution plan. So back of the mind, I was thinking maybe we can have a engagement with all these stakeholders that maybe we could figure a way out because see all of these proceedings, attachment, freezing, or this resolution plan, all of this will take a long amount of time. And considering that all of these assets are and all of these values and revenues are time sensitive, and this is a domain that changes every day for that matter. So they need speedy resolution to this effect. So I was thinking of something on lines of some kind of mediation or something with respect to the committee of creditors to come up to some testing solution. But then she mentioned the fact that all of these creditors who received higher stakes, say 40 to 45%, have some ties to the resolution professional or have some benefits accruing out of this project that are tied to prospective plans of the project. So keeping that in mind, I feel parties might be hostile in the first place to attend a mediation. I'll bring this up in the next meeting. Obviously, she's the one who has to choose which process we go by. But then I think I still prefer the NCLT challenge of resolution plan and fraud because I think we have a strong rational basis to go by.
Yeah, way more or less I am on this front with you because it is also important to note that there are when an RP's conduct is being challenged, it is important to note that RP is, as I said to her also, that in a very fiduciary capacity. Under Section 208 of the IBC and also under the IBPI regulations on professionals, RP has to maintain a conduct which is without any conflict of interest or favoring one party over the other. This means that the possibility that they have a continual engagement with other creditors could be a very important point that we need to raise, both in the ethics board, because it is important that such professionals are being flagged in front of authorities and not there for other procedures also, and also in this particular case, so that we can first set off the resolution plan. Because when a resolution plan has been approved, if it gets NCLT approval, then the procedure would become even more judicially tedious. So yes, I agree with you on that. What do you think was the point? Because we had a lot of discussion, deliberation, a lot of numbers being thrown here and there about the valuation and the independent test created. You were referring some flow. So what does your research tell about that?
So, firstly, I completely agree on the non-partisan behavior that a resolution professional must adopt. Onto the independent valuation assessment, see, the statute still does not factor in this, increased price assessment for this for this particular asset. However, that being said, since she is a dissenting financial secured creditor to that effect, she can obviously challenge the resolution plan, and once the resolution plan has been challenged, once the resolution plan has been struck down, then you can obviously pursue other aims through say surrogacy for expeditious attachments of assets or realization of their value. Today, we cannot pursue actions under SFAC because there is a resolution plan that has been passed. But once the NCLT strikes down the resolution plan, I think we have a better option. But then the first and the foremost short-term goal in front of us is to challenge the resolution plan in the first place. And I think she pointed out that there were some email communications wherein she asked the resolution professionals to provide her with the detailed valuation reports. However, she was only provided with the summary reports. So, this also attributes some amount of good faith that the courts will definitely look onto her. Because, see, courts generally prefer people who have had some amount of engagement with the process and who have not jumped directly into litigation. So, I believe the courts will look down to her very favorably in terms of this good faith approach. Anything else that you felt interesting or something that we should pursue research on with respect to the valuation or the fraud aspect?
Even even so if you see actually what the underlying rationale of this is when a court says that they will not change the valuation once the procedure has started, is because court is not meant to restart the process which the RP was supposed to conduct. It was an independent report giving the valuation. So 5 years later, even if the procedure is going on, court will not interfere with it. But once we strike it down, which we have legitimate grounds like Section 29A about the professionals and the IBBI regulations, once we strike it down, the current market value will also become relevant, apart from what we were suggesting. And I would say that other than that, there's always a chance of mediation with the other creditors also, because at the end of the day, they also recognize that Mr. Shah is a secured creditor. He has a right which can't be denied. And in such a dealing, a fair procedure adopted would be efficient, because that will be a quicker resolution and embarkment and receiving of money for them also. They also don't want their 82% to be struck for that longer. So that is also a benefit that Mr. Shah has and could potentially leverage against them. On the point of what could be researched more on, I think we need to research more upon once we receive the communication as to the standard that RP has to have, which means what conduct can happen, and also on the validity of just summaries being given. Is that something which is prima facie wrong, or what could be there? So that is a potential legal research area that I think we need to explore.
Correct, correct. On to summaries, there was this previous case I was dealing with. Therein, we researched on the fact that, if you give just bare summaries, the applicant or, someone who's challenging that report does not have the means to rely on what methodology did you choose to prepare that report in the first place. So that's deeply problematic to that aspect. Additionally, I believe, to pursue our thing on fraud and against the resolution professional and how they've all acted in a coordinated manner. I think the court will not agree when we just point out to one document and say, see, this is what we have on record, and thus this has to be corroborated against this. We must take into account, all agreements, all minutes of the meeting that were in place within that particular time period. So as to have a holistic understanding of what the picture was accurately to that effect. Additionally, I do agree that we can pitch mediation again to her, because secured creditors, the other ones would also possibly recognize at some point that what they're doing 45% to them and this 25-27% to Mr. Shah, that is an unconscionable bargain and that would not stand in court. And if it goes to court, if we challenge it, it will only stretch the process longer with unwarranted judicial delays, and that will only make the asset possibly lose its value. So, anything else that you would like to further on this?
I think yours point about why we suggested her a particular suggestion instead of alternatives that we could have gone, and also the fact that there are things like mediation with the other people or a complaint filed with IBBI, which is the professional body for what the conduct of the RP, is a very important thing. I think now we should also go towards the work division, which is possible, because it's a very time sensitive issue also. Once the NCLT approves it, then the problem will become even worse. The problem is that right now we only have summaries. So the process of actually appealing to NCLT, first proving that we need the actual report, and then also contesting the independent report is important. So I will look into that, but I will say you could look forward more about the valuations and the independent report.
Correct. Let's just get into this expeditiously and get this.
I think we have a productive time.
So, you said something about mediation.
Mediation between the secured creditors to the effect, because yeah, that's true. That is true.
I getting 85% can mediate.
I'll put this into picture, sir. So first, that is precisely why I offered her to challenge the resolution plan before NCLT. However, that would take delays, and she wanted an efficient mechanism. Now, I completely understand that this would. Why would they even want me to collude with them? But then they would also possibly realize in this entire mediation process that they have an unconscionable bargain, and their fraud, what we challenged, it would not stand in court. So anyways, they would decide that they'll be losing out on the resolution plan that they've agreed to, and and they might agree to a more, conscionable bargain, a conscionable setting to their effect.
So we look for the realistic part of the job. I'm getting 85. You just want to understand. I'm getting 85. You're getting 60, whatever. X less than mine. You have grounds not against me. Why should I? You might be the person who's not giving you. Whether I say that, why should I come and give you and waste my time?
Sir, if I could try and answer your question.
I'm asking you, give your answer. You think over it.
You're asking me?
I one more, sorry. You had said something about surface laws. You used the word surface.
Correct.
For what? In this context, where surface is coming, just want to understand.
Correct. So SURFACE cannot apply now because the resolution plan has already been passed. But once the resolution plan is struck down by the NCLT, when there's no resolution plan in effect, then we can pursue SURFACE and then for expeditious attachment of assets. So that was the plan in effect.
Sir, on this point only, I was gonna add, in the sense that we suggest that first, the suggestion with respect to mediation also would come into play and would be practical only after the NCLT procedure has been struck down. Because at that point, even the 82% holder would not have a resolution plan in place. Their concern as an 82% owner is that the resolution plan gets in place and that they need to ensure a fair procedure. So a mediation process where we are able to say that our only concern is that it is transparent and not unfair would also be beneficial to them and may potentially get them to the table.
If the parent with the bona fides, then why can't you just go to the court itself? I mean, when there's a proceeding already pending, why not approach the court rather than resorting to litigation, which is even more time consuming?
Correct, ma'am. That was precisely what we advised our client, that we must move the court and we should do this expeditiously. Because once the resolution plan is passed by NC, currently is pending judicial approval, but once it gets the approval, we will be left with no recourse. Now, a first step, the short-term goal that we proposed was to challenge the resolution plan in the first place.
When you say challenge, how are you challenging?
Under 32. So, under section 32, a resolution plan which has to be approved has to meet certain criteria. One of them being, say, it should meet the independent valuation as the basic threshold. The other one being that the independent professional was not unfair. So, we are challenging it under those statutory grounds. After it gets struck down are the other remedies that we are suggesting. So, because of the lack of appropriateness in the procedure, we are going to contest that the resolution plan should be struck down in the current case, and then that would be the remedy you would ask the court.
I don't believe that the client disclosed, what stage the proceeding was, currently at.
No, she told us that it is pending judicial approval. It has not been passed.
Okay. And what does that confer? I mean, in your opinion, what does that confer?
So, according to her and the timeline that she has given to us, after the resolution plan was passed, she has said the NCLT has not approved it, and she has also said that there has been no disbursement of money. So, according to us, it is pending, and there can be raising of points at that stage. Yes.
As your client, I have a few questions. First, you mentioned you challenged the people. What the people non-compliance will violate?
I was saying, I think the point was pretty circular.
Yes.
Correct. So, firstly, the main thing that we're challenging today is the fairness of the procedure established. Correct. But then that's within the broad ambit of the statute. Even if you look at 65 on how a resolution professional must act, it has to act in a non-partisan manner in fiduciary duty.
And also on 32, 30 subsection 2, the point was that I think there is a requirement that the independent procedure was followed and it has to be without the flow.
For independent process, the process is specified 32 is the mandatory contents of the resolution plan. That doesn't talk about independence, separate profession, but it comes to that.
Ma'am, just to clarify again, under 32B, which is the requirements of the particulars of the resolution plan,
So since you mentioned 32B, what does it say about authentic financial?
it says that the plan should not go below the floor which would have been possible by a liquidated at that point. So if today we find that the report suggested that the valuation at that point guaranteed 110 crores by their liquidation, then the plan would be
110 is the fair value. It's not liquidation liquidation value.
It's the
Liquidation value is the estimated realizable value of assets that is sold during liquidation. Fair value is a completely different.
That's correct.
Right?
That's
So if they are getting liquidation value, plan is still compliant. That brings me to my second question. Why do you think that we need to set aside the resolution plan itself? Why don't we get the plan through and change the distribution if that's the way?
Ma'am, the IBC is based on the fundamental premise that if the plan goes by, we must understand how the plan was enacted in the first place. It was through unfair procedure. So our main submission before the court would be to value the procedure. The procedure must not be unfair in the first place. That being said, we put on minutes of the meeting record. We put in all.
What is the end goal of your plan?
To receive the fair
Is it on
share.
the process or is it on the number? What is the
To receive the fair share. And to answer your question, the problem would be that if the final resolution has been passed, then IBC will grant it finality. In the sense that we will.
no, so that's what my son just put. Sorry to cut you short, but my question is that let's say your plan is 300 crore value plan, right? You want more of than what is given for you in the plan. So it's a question of redistribution, it's not a question of the compliance of the resolution plan. So you can always, is that a possibility that you think can be explored?
Ma'am, I completely agree that redistribution can be explored. However, we must also take into account the factors which influence this resolution plan. Ma'am, the creditors in this particular case, they have their outcomes tied to the future prospects of the project. They've been receiving, and that is not something that we can possibly remedy by say redistribution, something to that effect. That collusion has to go in the first place, and the procedure must be fair. So that is the precise reason why we're challenging the resolution plan.
just to add to the question. That question is that I am getting 25%, she is getting 25%, others are getting 40%. The NCLT, can you treat there make 40% for everyone? Can NCLT allow that?
Sir, NCLT always values the commercial decision of the COC. However, the commercial decision of the COC is not beyond judicial review. If it is found that it is affected by, say, patent illegality, perversity, and fraud, which
So your answer to her is that you cannot change.
correct. You cannot question the commercial wisdom of the COC. However, you can challenge it on other grounds such as fraud or patent illegality.
Let's say what the procedure is.
Correct.
You have a problem, so keeping aside the number for a moment, what the other point that she had highlighted was that there is a staggered payment proposed for the other creditors and some upfront cash is being proposed. As a dissenting financial creditor, is it possible for her to get a staggered payment on the principal? Even if the number, let's say they agree that I will, the resolution applicant agrees to modify the plan, let's say I bring you at par with the other creditors, but the timeline for the payout for dissenting financial creditor will be a staggered payment over a period of 10 years.
Ma'am, in our particular opinion, what would matter is the possibility or what is the role of each body. So in this particular case, if the RP suggests that she should get staggered payments, while the other 82% shall get the upfront payment. The court cannot go into what should have been the particular merits or the commercial wisdom of the RP. The court would go more on the procedural aspects that if that reason was wrong.
I'm talking about what is the position of law. As an advisor, I think that as a dissenting financial creditor, I should get in cash in priority to the dissenting financial creditor. Right? A staggered payment, even if you are giving me at par with the other dissenting financial creditor, may not work. But do you think that's the correct approach or anything else should be considered?
Ma'am, the object and purpose of IBC and of realization of assets is that you realize your debts as soon as possible in an efficient manner to that effect. So if they are delaying payments or time payments to future prospects, that may violate that object and purpose of the statute completely, and we may challenge it on grounds. I believe there might be some additional provisions in the statute to this effect, which we will research and come up better with.
I have just one last question. She mentioned about valuation and the fact that there is a change in the economic scenario basis which current valuation should be considered? What does your law currently encompasses? Because the, you also mentioned whether or not you have done any independent valuation. All of that can become irrelevant if there is a currently the law prescribes something and that has been eliminated.
Ma'am, if I can give a two-pointed response to that. The first one, we agree that a fair value of the current time would not be considered because the courts are concerned with how the resolution procedure was formed. And in that, when the process was initiated, the valuation at that time was accounted into. Our suggestions went because of the extensive engagement with the client to the point where we are saying that set aside the award and consider a fair valuation. My second point to you would be that the independent report which we were suggested to get was to assess whether the first report which the RP relied upon was actually true or not. Because if we are able to prove that itself was true, that will vitiate the procedure and thus remove the procedure and help us set aside the award.
Yeah, that's correct. But then the client said that it is their company which is undertaken assessment. So if I go to court today to say that okay, we have conducted this assessment to this effect, the court may not trust bona fides of my report. So I suggested that we must have an independent accounting report or valuation report from some other party, say a big four accounting firm to that effect, so that independence or the bona fides of the report are not questioned by the court to that effect.
Thank you so much for your questions.
Thanks. Thank you.
This council one. Given the initials you have.
They were external names. My experience was clean and his experience was good.
You said I agree before. It should have been other way.
Yes, sir.
Okay, just one minute. What else we did, sir? We have a please. आयडिया करून तुम्ही घेऊन जा ना. काय बोलला? आयडिया काम त्यांचं तरी आहे. काय? अजून काय? म्हणजे ते कुठे आहे? ऑर्डर 6:30 को है उसमें भी गेज लेने हमें गेज 6:30 से कितने मीटर
ऑलरेडी देते ഇത് ചോദിക്കുക ഇപ്പോഴും ഉണ്ടോന്ന്
വിചാരണ വിചാരണ
हाँ क्या
ഇപ്പോഴും കാര്യങ്ങൾ ചെയ്യാനുണ്ടോ ചോദിക്കുന്നത് ക്ലോസിംग സെറമണിയൊക്കെ ഇപ്പോൾ ഇവിടെ
माझं किती वेळ लागेल 7:30 वाजतील
ഒന്ന് വേഗം ഒന്ന് ചോദിച്ച് പറയുന്നത്
मी
आमरे
काय बंद करायचं काय
बंद नाही करायचं
6 घंटे येते 9
कंटाळा येतोय.
घंटे ना मित्र
एक जण पाहिजे ते इकडे तिकडे लागलं तू आहेस आता मी आहे
का बोलले का ते
Yes, I. What is that? We have that.
Yeah,
They were like asking, can you tell me the sectors of tell me the data? Like specific coincidence. The opposite send the yellow arrow. Low power mode. Change the arrow. Then look for a power. Push. Take the power and the light to नीचे जल्दी किचन का पिंक का एक बड़ा ऑरेंज प्लस कॉफी ब्लू का ये कोई बात नहीं ब्लू रेड का देखो let's be we have to send this yellow to send the red and then send yellow let's say to send the brown in the space for sending the pink you can send light blue to the light blue send
I would not have gone for the power.
I don't know.
Sorry, I started. Can I harass you for a couple of minutes? Feedback on my end. What I mean, I think in general, how did you like it? What are things that I could perhaps take away and improve further rounds?
Okay. Tell me. Go.
Yeah. Yeah, I got it. Yeah.
No.
Other
First
things
week was okay.
yes. The second thing was
Yes. I wanted to know.
So logistics speaking, but yes. But I also think that is shocking, probably 50%.
Yeah.
No, it's like my first round. It is a very the woman basically tells me that
See, you have taken my
Yeah.
test originally from Webber. Now it's 47. I have something other to do. That's it. I came because I committed that. Just a
ठीक है सर थैंक यू सर बट या थैंक यू
Okay, I'll give you feedback. I wanted to give you feedback separately. You are good. You get stuck on it. And then you will lose. You have to like a broken wing. And then you always slip. You get stuck on a point. I mean, from your personal way, you have to learn. You start moving away. Don't feel bad. But I don't lose my level.
Yeah. We should do that.
Not you. I'm talking about him. I have
So if I might add you as a partner,
I know. No, I'm not calling you somebody, but some fiduciary everyone who will be working you want to give back to fiduciary. कॉन्स्टिट्यूशन एक ही चीज कितना बोलेगा वो भी घूमा फिरा खाता है तो फिर से उधर निकल जाता है तो ये भी बहुत अलग I like your personal feedback. I like the way you summarize. You got a new way. I like the way you talk about it. But I also like think last thing you stuff like that. Just say that you need to do it. You need to understand how to do it. This happened with experience. So that if I don't want it, I put it I say it for that. I'm just telling you from experience. In my second year, I was doing like that. You need to learn. Obviously, with my time, I did the second year. I just went to bed. No, I like this thing. I feel it's kind of and don't use big words. You have tendency to use big words. Nature is you're made of Shashi Khan.
Beyond that, into this point, limit your exposure. Statements, visions, it's all about factors. What you read up, basics of steps. It's just condition explanation.
You have just as if I gave you it becomes the basis for your human when you really have an impact. You probably discount the policy. If you focus on regulation, reduce your exposure to temper expectation. Narrate that in 10 minutes, and then maybe in the next 5 minutes talk about it. These are the things we need to form and subject of appropriate then. Only when you have something that can I remember this very good. I was talking very he asked my partner. He said, only on that yours, my question, revive the rate. How everybody is
Yeah, we still have.
Good evening, everyone. I am Vedant Kalaburkar, the event co-head. On behalf of the organizing committee, I extend a formal welcome to our esteemed judges, respected faculty in charge, and all our participants. It is a privilege to host you at the advanced rounds at the valedictory ceremony of the second National Corporate Client Counseling Competition. The second edition walks along the same vision as its predecessor to enable the participants to simulate the first stage of the real world corporate affairs, the client counseling. As aspiring corporate lawyers ourselves, we wish to make sure the law students have a channel to experience what their upcoming future will be. From its inception to this stage, the competition has been defined by rigorous preparation, enthusiastic participation, and a shared commitment to excellence. Beginning with 38 teams and progressing through multiple evaluative stages, we now stand at the culmination of a journey that has tested not only legal knowledge but also practical application and professional conduct. I now hand over the mic to my event co-head Deepak.
Thank you, Vedant. Moving forward, talking about the competition, what distinguishes this competition is focus on bridging the gap between theoretical legal knowledge and the realities of corporate practices. Client counseling demands clarity of thought, precision in communication, and the ability to offer commercially viable legal solutions and skills that are essential in professional sphere. Over the course of the rounds, participants have demonstrated these competencies with remarkable consistency. The advanced rounds in particular have reflected a high degree of analytical depth and professional maturity. With this, we formally commence the valedictory ceremony. I now invite our faculty in charge, Mr. Sajid Sheikh, to address the valedictory ceremony.
A very good evening to all of you. Along with the organizing committee members, I can say that we are feeling happy as well as relieved that we are concluding this second National Corporate Fight Counseling competition at a very, very high note. And as in the previous address also I stated, which our head also said that legal education is not only about the law books which we read, but it's also about the understanding, the skills, developing skills. And this particular client counseling competition is more about understanding your client, understanding the nuances of the particular problem, ensuring that through, apart of course, legal education, the knowledge of the concepts that is important, but understanding and building up that very trust within your client, that is very very important. And on behalf of Maharashtra National Law University Mumbai, and on behalf of our Honorable Vice Chancellor Dr. Dilip Bouquet, our respected Registrar Dr. Prakash Chaudhary, and on behalf of our Center Director Dr. Nanda, I immensely thank our esteemed industry experts, Mr. Ashish Philip, Mr. Bhargesh Ocha, Mr. Harsh Lonkar, Ms. Athira, and Ms. Survi Parekh, that they have spared their valuable time to guide our students, mentor our students, also judge this very competition. And I can see that, it has been a very, very long day, but still many of you are here, and it's because of that very love for the institution and love for our students that you chose to be part of this very valedictory session as well after, judging the competition. So, I really thank all the participants who were part of the earlier sessions, also quarterfinals and these advanced rounds as well, and particularly the organizing committee members, because I have no shame in saying, but I'm very very proud to say that this whole competition is managed by the student members themselves. And please give a round of applause for all the organizing committee members. Day in and out, they have worked immensely to have this very competition and to manage each and everything. And I thank all the teaching, non-teaching staff members, all the students are here observing this very program. Thank you so much for your efforts, your contribution in making this very event a very, very successful event. And I'm also very eager to see the award ceremony now. So let us wait for that. Thank you all. Thank you once again to all the experts.
Thank you, sir. We now move on to the most anticipated segment of the ceremony, the presentation of awards. I request our faculty in charge, Mr. Dr. Sajid Sheikh, to present the awards. The first award for the best client goes to C4 Jayantika Ranjan. The award for Best Counsel goes to Arya Harishankar from NLS Bangalore. Due to some medical reasons, she won't be able to collect the award. So, moving.
Somebody else collect out there. They will be from the same
team from NLS Bangalore.
Handover. Actually, handover. Yeah. Please congratulate her. Congratulate her on.
The award for runners-up of the competition goes to TC02, Siddharth Kaushal and Khushi Pawani. Finally, Finally, the winners of the second National Corporate Client Counseling competitions are TC07, Shashwat Shankar and Mr.
Judges and all the partners. And these are winners also.
All the winners will come to the stage.
Just a moment.
Some of you join this side also. ओसी के साथ जो भी अपने पार्टिसिपेंट्स हैं हाँ आज आओ
Congratulations to all the awardees for their outstanding performance and well-deserved recognition. Your efforts have set a benchmark for excellence in this competition. I now hand over the mic to Vedant for the vote of thanks.
I now take this opportunity to propose the vote of thanks. I extend my sincere gratitude to our esteemed judges for dedicating their time, expertise, and effort in evaluating the rounds with diligence and fairness. Your presence has been instrumental in maintaining the standard of the competition. I would also like to thank our Vice Chancellor, Dr. Dilip Bouquet, our Registrar, Dr. Prakash Chaudhary, our Secretary Director, Dr. Nanda Parthe, and our Faculty in charge, Dr. Sajid Sheikh, for the continuous support, guidance, and trust in our vision. To all the participants, thank you for your commitment, preparation, and the professionalism you have displayed throughout the competition. Your involvement has been central to the success. I would like to thank our convener, Suhasini Thakur, and our associate convener, Ekam Khaira, for the consent, guidance, and throughout the organization of the event. I also acknowledge the efforts of the entire organizing committee. Without the combined efforts of everyone, this event would not have been possible. The execution of an event this scale requires coordination, discipline, and sustained effort, all of which was demonstrated consistently. Finally, I thank everyone present here for being part of this event and contributing to its success. And I invite Dr. Sajid Sheikh, our faculty in charge, to provide the mementos of the judges.
OC members also please rise.
Mr. Bhagesh Roja, please.
Once again, sir.
Mr. Harsh Lumkar, please.
A picture is ceremony also.
Miss Atira. Thank you so much for your time today. With this, we declare the second National Corporate Client Counseling Competition closed.
Yes, sir.
वो मेरे को फोन क्यों बोले लड़की खड़ी थी वो हटा
कैमरा ये है ना इसके पास। Ready.
आपको तो ये दिखा दे दिखा देना
सामने देखो।
Right side.
Three, two, one, please.
Thank you so much.
I really hope it's done. Can you check?
You should always take two.
I took four, sir.
like end time season end shift yeah